Good morning, good afternoon, and good evening, wherever you may be on the globe today. And welcome to Silicon Valley Arbitration and Mediation Center's fourth annual Paris Arbitration Week program. I'm Les Schiefelbein, and I'm the Chief Executive Officer of Silicon Valley Arbitration and Mediation Center. Before we begin today's great program on arbitration and trade secrets, I'd like to say a few thank yous. The Paris Arbitration Week Committee for continuing an affiliation with Silicon Valley, and we hope it continues in the years in the future. To our attendees, to Stan Pooter, who will be our moderator, and our panel members, and also to a Silicon Valley Arbitration and Mediation Center tech list appointee, Alex Blumrosen. Alex has been the lead Silicon Valley member dealing with Paris Arbitration Week over the last 4 weeks, and unfortunately he had a conflict today and could not join us. Just a word about Silicon Valley. We are not an arbitration institution. We are a nonprofit whose objective is to advance alternative dispute resolution and technology business disputes. We're an international organization. Approximately 40% of our members live outside the United States. And we have a number of divisions in Silicon Valley. And if you're interested in our membership or our young professional organization, please just go to SVAMC.org and you can get the information you need. But now to our program, and I wish to introduce our esteemed moderator, Stan Pooter. Stan is a partner with the Small Lugangu lawyers in Rotterdam. He's chairman of the Dutch Arbitration Association, CEO of the Court of Arbitration for Art, and a member of the Silicon Valley European, Middle East, and Africa Committee. Stan runs an international commercial dispute resolution practice. His practice is primarily focused on international arbitration, arbitration related to court litigation, asset recovery, and injunctive proceedings. He has been involved in approximately 90 arbitrations as either chair, sole arbitrator, or co-arbitrator. He draws his practice and his mandates, particularly from clients from the offshore, energy, finance, technology, petrochemical, and construction and engineering industries. Stan is an internationally known and recognized alternative dispute resolution practitioner. And Stan, please introduce the program and your esteemed panelists.
Les, thank you very much for your introduction and your welcoming remarks. Indeed, without Alex Blumrosen, we would not have been here today. So in his absence, he is still thanked very much for his efforts pulling forward the POL SVAMC annual event. All right, so thank you all for joining. It's a webinar that we have today instead of a live event. There were occasions that we've considered it possible to have an in-person session again this year. Others have indeed chosen to do that this week. We have chosen to do a webinar and assume that next year it is again possible to see each other in person, where Alex will probably again be hosting us. Right. We consider this to be the safe bet actually today. Arbitration and trade secrets, that's the topic of today. We have lined up, in my view, a stellar panel with a great diverse number of panelists. And I would like to introduce them to you first and then run you through the panel that we will be having today. We've got no less than 5 panelists today that will all share their views on trade secrets from their own individual perspective. Starting off with Sana Belaid, if I'm pronouncing it correctly. Sana, we are very happy that she is here. Sana is a senior legal counsel at Cisco. She's also a member of the ICC Court of Arbitration and a member of the User Council of the Swiss ASA Arbitration Association. She has a long background in dispute resolution internationally and arbitration in particular. She has worked for major law firms in Paris, including White & Case. She has obtained not one, but several post-master degrees. She is a Tunisian citizen, fluent in Arabic, English, and French, thus having worked in Paris, but now moved to Dubai and working in the UAE for Cisco. Aside from being an in-house lawyer with arbitration experience, she's also an executive coach. Sana, thank you very much for joining us, and we very much look forward to sharing your views on trade secrets. Right.
Thank you for having me.
Of course. Next one, Claire Morel de Westgaver. She's also a great panelist. Although she is a little bit sick today, she has made the effort to not cancel, but join us. And that's very much appreciated. Claire, thank you for being here. She is a partner in BCLP's International Arbitration Group, works out of the London office, but is from Belgian background and has obtained her law degrees in Belgium as well as the United States. And after having obtained those degrees, she has qualified in England and Wales, but also in New York. So she has a great civil common law knowledge. She works as arbitrator, as advocate, of course, and in mostly international arbitrations, conducting proceedings not only in English, but also in French, and maybe also if a dispute would arise in Dutch. No, okay, not preferred, I see, very good. Claire has particular experience of disputes in the technology industry, corporate transactions, license disputes, sale and services agreements, and all kinds of issues relating to secrecy, confidentiality issues. She has a busy Thursday today, as one of the reasons, not only because she's a panelist here, but also because she has set up together with a couple of other arbitration lawyers Mute Off Thursdays. Great initiative, which we just discussed a little bit still. And she also is a board member of the SVAMC, sits on the task force of the ICC on the use of IT in arbitral proceedings. What's there more to say? Thank you very much, Claire, for being with us today. Moving on, to keep the panel a little bit diverse, we chose also to have one male panelist today, Ignacio de Castro, which is the next speaker on board. We're very happy that he is here as well. He's the Deputy Director of the WIPO Arbitration Center, and as such is in a perfect position to share all his insider knowledge from within the institution. He's a Spanish, but also an English solicitor and holding a LLM degree from King's College in London. Aside from working now for WIPO, in the past he's worked for the United Nations, but also from with a large international law firm, Freshfields. Ignacio, thank you very much for joining us today.
Thank you, Stan.
Moving on, Patricia Jonesy, a next speaker that we have. And although the name would not ring a bell that she is living and working in Stockholm, she does do it. Thank you very much for being here. She's an international dispute resolution specialist. She was a vice chair of the board of the Stockholm Chamber of Commerce and has served on that board as well. Active member of drafting the latest revision of the SCC rules. She is teaching, I believe, as a professor at Stockholm University as well. And as one of the tasks that she takes on is a appointment as confidentiality advisor in certain projects. And that's specifically the issue that she will be addressing with us today. Patricia, also to you, a very warm welcome. Moving on to the last speaker that we have online, Sarah Reynolds. She's a managing partner of Goldman Ismail in Chicago, previously working for Mayor Brown in the same city, I believe. She represents technology and pharmaceutical companies in domestic and international arbitrations, including under the auspices of the most well-recognized global institutions. If I believe, she is splitting her time between Silicon Valley on the one hand and Chicago on the other hand, having recently been relocating her time or dedicating more of her time into Chicago again. Sarah, thank you very much for being here. Right, after having now done the introductions of all of our panelists, I thought it was wise to move the audience towards the next phase and introduce the panel setup that we are having today. We believed it was good to break down this panel in a couple of sections, starting off with providing all of our panelists the opportunity to give a bit of an opening statement on trade secrets in arbitration from their respective backgrounds. Sana, she will take the position that she has in-house, an in-house perspective of trade secrets. And then Claire will share her views as counsel. Ignacio will take the position from the institution, Patricia, confidentiality advisor, and lastly, Sarah will share her views from the perspective of sitting as a tribunal member. After the opening presentations, we will move forward with a panel discussion. And after the panel discussions, we will be having a Q&A session with the audience. The audience is encouraged to put and list their questions down in the Q&A function that we have. So preferably not use the chat function for the questions, but only the Q&A section. We will list those, compile those, and at the end, after the panel discussion, we will go through these questions. So that's a bit of the lineup that we have thought of today. So it's then the time to move over to the opening presentations with starting off Senna taking the floor with a presentation from the in-house perspective. Senna, floor is yours.
Thank you, Stan, and I'll be very happy to present my own views on trade secrets based on the experience that I've had over the past years as a private practitioner and also as in-house counsel, as you rightly pointed out. So what is a trade secret? A trade secret is not more or less than information. It is information, but is one of a kind. It is an information that has an independent economic value, whether it is actual or potential. And this value derives from the fact that it is not known to the public, or it's not known to those who could take advantage of it, undermining by doing so the value that it represents to the owner of the trade secret. So in addition to being an information of value, it is also a piece of information whose secrecy is being protected by the owner through what most institutions and courts agree to call reasonable measures or reasonable efforts. There are four basic elements that will help us define a trade secret. So once again, it is necessarily a piece of information. Generally speaking, this is information that's either technical or commercial, which is giving a commercial edge to the owner. The fact that it's secret is giving it this, this specific value. Basically, a trade secret is a piece of information that others will need to invest money and time to find out or to develop. While me as an owner, I've already went through this to find it out and to be the owner of it. And the information is not generally known to the public. It's not known to the industry. It's not known to the competitors. It's not known to anyone who could derive value from it. Sometimes if it's known to just a very limited number of people, but these are specifically the people that you want to protect it from, then unfortunately it will no longer be trade secret. This is why we will see, I think during the session, how fragile trade secrets are and how important it is to protect them. So this information has to be treated as confidential, as I said, as secret even, by the owner, who will have to put in place reasonable measures to maintain its secret existence and also implementation. Unlike patents, unlike copyrights, and as being outlined by WIPO, you cannot stop others from using your technical or commercial information that you consider being trade secrets. Since trade secrets are not public and they are not registered with the authorities, and like patents, for example, they do not have this defensive protection that a patent would give you as being prior art, for example. So this is one of the reasons, once again, they need to be at the heart of a protection mechanism process by the owner. Now, when we talk about a protective mechanism, we're not talking about anything that is surreal or particularly stringent. We're talking about reasonable efforts. Many courts, many judges insist on the fact that these should be reasonable efforts, such as, for example, advising your employees as the trade secret owner of the existence of this trade secret, of its nature, limiting access to it by others, to, for example, on the basis of the need to know grounds, requiring some employees to sign confidentiality agreements, of course, making sure your employees do not mention this in PR statements, in public announcements. Sometimes you have to keep these documents under lock. You have to put probably a confidentiality or a secret stamp on it, on them, sorry. So basically you have to genuinely care for your trade secrets so that others care for them, basically. You have to reasonably, do your best, all commercial efforts to show that they are important to you, but also to keep them as secret and important. So talking about the importance, how important are trade secrets to companies? And what I noticed through my experience, and once again, I'm expressing my own personal views here when I talk with peers and practitioners, sometimes companies do not value their trade secrets. When they talk about their portfolio, they think about patents, copyrights, everything that is registered and has an official stamp on it. While a trade secret might be actually even more valuable, and probably sometimes your trade secrets as a company are even more valuable than all the patents that you have, because they actually guide your commercial efforts on the market. They guide your technical edge. They make you at the origin of a very specific value on the market, and you don't want others to know about it. So obviously, a company will not announce that they have trade secrets, because by definition they should be secret, but it should internally make sure that it has the right processes to keep it secret. As I said, this information is generally commercial or technical. And when I say commercial, it means that it is based on years of market practice. It is based on a lot of experiment. It is based on your knowledge of what works and what doesn't work in a specific industry. It's also a lot about what you learn from your mistakes as a company. It's also a lot about your market strategy. Which geography is most relevant to you, which product line is more valuable to you, where is the future in your specific industry. And this works for all industries, not just IT companies, not just energy. It's true for all companies. And I remember that the first time I got a sense of what a trade secret is, I was in Paris and I was 5 years old, and I fell in love with Bertillon ice creams. And when it was time to leave Paris, I was very sad. And I told my mom, it's easy, you just, you make the same ice cream at home. And Dad, I remember that said, no, their recipes are kept secret. And I believe this was like one of the first contact I had with the trade secrets, so that we understand that, it shouldn't be some magic formula. Sometimes it's a very, easy, or if I say, it's a very down-to-earth combination of information, but it presents a lot of value for the owner. So I thought I'd give you some examples on of what trade secrets could be. Probably this will come out in the discussion with the panel later. So for technical information, it could be plans, it could be designs, processes and formulas, methods and techniques of manufacturing. Sometimes, as I said, it could be the process not to apply, the technique not to apply, because we know after years of experiment that it didn't work. And the business information, of course, the financial information, that's a no-brainer before they are released. The cost and the pricing information on products and goods. Customer lists, this is very important, which are your strategic customers in the region. Also business opportunities that are identified, and of course personal information, who are your key personnel, their skills, their added value to the company. So as I said, once again, it's a big range of information that is very valuable and at the same time very fragile. And I'm counting on my fellow panelists to help us make them not as so fragile during arbitrations. That's it for me.
Yeah, thank you very much, Sana, for those opening remarks. Giving the floor then immediately to Claire to share her views from the external counsel perspective. Claire.
Thank you, Stan, and thank you, Sana, for this wonderful introduction in some ways, setting the scene for further discussion on trade secrets and arbitration. So I'm going to effectively build on what Sana has so beautifully explained. So as she said, like a patent or copyright, a trade secret is not registered and it will not expire as long as it remains secret. So if the information that Sana talks about constitutes a trade secret, is not protected somehow, and that its owner is effectively a bit negligent about taking steps to protect it, the owner will lose the IP rights in that information. It's exactly like a secret. If you don't protect the secret, and you don't tell people that they shouldn't repeat it, it's no longer a secret. So what does that mean for arbitration users, arbitration practitioners, arbitrators, and the practice of international arbitration? Well, in my view, there are two areas where arbitration and trade secrets intersect. So the first effectively crossover is the question as to how an owner of a trade secret can preserve it, so protect that trade secret as part of an arbitration proceedings. So the first area, preserving trade secrets in arbitration. I will develop that a little bit later. Second area of overlap between arbitration and trade secrets is an area that is quickly developing, and is the arbitrations that relate to trade secret disputes. So I will say a few words about that as well. So starting with the preservation of trade secrets in arbitral proceedings, before I give you, I share my experience as to, when there may be questions as to the preservation of trade secrets in an arbitration. I think it's important to remind ourselves of two angles from which confidentiality in arbitration should be looked at. First, when we talk about confidentiality in arbitration, we should remember that there is a need for confidentiality within the process. When I talk about confidentiality within the process, I talk about confidentiality of information that could circulate within the arbitration. So confidentiality vis-a-vis effectively other participants in the arbitration. That's the first way in which confidentiality in arbitration should be looked at. The second angle I would submit is confidentiality of the arbitral proceedings vis-a-vis the rest of the world. Okay, so this is now no longer confidentiality vis-a-vis other participants, but confidentiality vis-a-vis the rest of the world. Starting with the confidentiality within the process, in my experience, there are three potential points or phase in the arbitration where there is a high potential or risk that trade secret may have to or may be disclosed. The first point in time where this could happen is where the trade secret is at the heart of the disputes, and the owner of the trade secret considers that actually there is a need to disclose the trade secrets to explain its case, plead the case, or meet its burden of proof. So those are usually the instances where it's the tension between protecting the trade secrets and winning the case is the highest, right? Because the trade secret is at the heart of the disputes. The second point in time where there is a risk of disclosure is document production. As you know, in arbitral proceedings, there's often a chance or an opportunity for parties to make document requests or data requests from the other side. Generally, the test is relevance and materiality. I think we all know that, and we also know that there is also generally an opportunity for the party on the receiving end of a document request to oppose the request, relying on certain grounds, for example, privilege or irrelevance. One of those grounds under Article 9.2 of the IB rules is commercial or technical commerciality, and this is the trade secret ground. There is a recognition in that soft law of the position to a document request on the basis of trade secrets. So this is where this is the second area where there may be a tension between the need to protect the trade secrets and comply with the procedure. The last one it doesn't necessarily come after that, it could come at any point, but I think there are sometimes defenses that are raised with respect to the pleadings and the lack of particulars. So where again there is a tension between the need to comply with the procedure or win a case on the one hand, and on the other one preserving the trade secrets. So what I've seen in practice is where one of the parties, not the party that owns the trade secret, but the other one, that effectively say to the tribunal, I don't understand the other party's case, unless the party sets out their case, whether it's a defense or a claim. I just don't understand. I can't respond to that defense or claim. And this is effectively, a tactic to effectively force the other side to disclose the trade secrets. And again, we can see the tension between, on the one hand, the need to protect the trade secret, but the need to respond or win the claim or the defense. So now moving on to confidentiality vis-a-vis the rest of the world, there are again some tension. First of all, we assume often that arbitration is confidential. I think we all know that it's a mistake to assume that all arbitrations are confidential. So one thing to check, of course, if there is a need to protect a trade secret in arbitration, is that the arbitration is actually confidential, either under the rules or the applicable law. And if it's not, then a good practice is to make sure that there is a protective order in place, so that at least the delineation of the arbitration, what separates the arbitration and the rest of the world, can be as leak-proof as possible. Another area to watch out is documents that could lay out the trade secret. Some documents in arbitration are less likely than others to end up in the public domain, even if the arbitration is confidential. But for example, orders and awards are more likely to come out, even though the arbitration is confidential. For example, awards are sometimes subject to enforcement and annulment proceedings. So the question is, should we ensure that the trade secret is not laid out in those documents? And the third area where I think what we need to watch out is cybersecurity. If an arbitration is confidential, and on paper, I would say technically, there's also a risk of a breach of security. So protecting the trade secret within the arbitration is one thing, but then and ensuring that there is a protective order to ensure the confidentiality vis-a-vis the rest of the world is another thing. But there is arguably also a need to ensure that the arbitration is secure, and this is where we see increasingly in procedural orders, terms of reference, cybersecurity measures that are being adopted to hedge effectively those cyber risks. Now moving on to the second crossover area of arbitration in trade secrets, I wanted to say a few words about the arbitrating trade secret disputes, which in my experience is becoming more and more common. Trade secret disputes typically relate to the alleged misappropriation of trade secrets or improper use of confidential information. These disputes can involve different types of claims, including breach of contract claims, tort claims, but also statutory claims if the trade secret law is embedded in a statute. Agreements, including arbitration clauses and giving rise to those disputes, generally involve some kind of sharing of information. They can be license agreements, non-disclosure agreements, development agreements, joint venture agreements, manufacturing agreements, consultancy agreements, also employment agreements, as Sana alluded to earlier. And so, as I said, those claims generally involve allegation of misappropriation. What about the defenses? Well, they often revolve around contract interpretation issues, and typically the way in which confidential information was defined. In those type of contracts where there is a sharing of confidential information, the confidentiality clause is generally very long, with lots of caveats, and sometimes there are some mistakes and some ambiguities. Another type of defense, current common defense in trade secret disputes, is that actually the owner of the trade secret, so the claimant generally, has not taken adequate steps to protect it. So effectively the right into the confidential information is no longer there. Often allegations of use, so there may be very technical arguments and submissions being made and evidence being submitted about a potential product, for example, the question being, does the fact that the defendant has put this product on the market, does that necessarily imply that the confidentiality information at stake was effectively used? There may be arguments as to the ability of the defendant to having developed the product independently. So those are the kind of agreement of arguments that you see in those types of disputes. Before I stop, maybe just a few words about awards. I mentioned earlier that in trade secret disputes, well, as part of preserving trade secrets in arbitration, one may consider not laying out the trade secret as such in the award. While in trade secret dispute, this could not be. It may be that this is impossible. So again, something to, I think, keep in mind when sitting as an arbitrator. How will an arbitrator or arbitral panel reason an award without actually disclosing the information? And finally, a few words about a potential finding that the trade secret is invalid. For example, if the defendant has not taken appropriate steps to protect it, if there is a finding of invalidity, query whether that finding affects only the parties in the arbitration or more. There is really no answer to this, but something I think to keep in mind when for anybody involved in trade secret disputes, because that could have a major impact on the way that the arbitration is conducted. If there is a risk that the arbitration on its own and the decision could have on the validity of the trade secrets. Thank you.
Claire, thank you very much for your insightful thoughts in your opening presentation. I think there's enough food for thought and enough questions to be raised during an interesting panel discussion. So thank you very much. Moving on to Ignacio then, and Ignacio is going to use some slides, I believe. Ignacio.
Thank you, Stan. I hope you can see my slides. Thank you also to Sana and Claire for their initial presentations. I will try not to repeat what they've said and try to complement seen from the perspective of the WIPO Arbitration and Mediation Center. So, of course, the WIPO Center focuses on IP and technology disputes. I'm based in Geneva. I have colleagues based in Singapore. We are part of WIPO, which is the World Intellectual Property Organization. And we therefore have some international neutrality. We administer the disputes under the WIPO rules. And the WIPO rules are quite unique because they have very specific provisions on confidentiality, including the protection of trade secrets. And I'm going to refer to these rules in a minute. We also have, of course, a database of mediators, arbitrators, and experts, over 2,000 worldwide, including experts in the different areas of IP and technology. In terms of the caseload, and I will focus on the areas of caseload where we often see trade secret issues arising. Patents is the main area, and we see trade secrets as part of patent disputes in many cases. These are pharma cases where there may be issues of know-how and show-how. You may have mechanical patent disputes where you may have some manufacturing processes, but we also see trade secrets in relation to the ITC related disputes, either in software licenses where you may have issues concerning source codes, or for instance, in the area of telecom and standard essential patents, where you may have issues relating to comparable licenses. These are, as you know, these FRAND related disputes, fair, reasonable, and non-discriminatory licenses. And there, these issues of comparable licenses may arise. We also see trade issues, trade secret issues arising in some commercial disputes, more contractual disputes, and in particular in relation to some franchising disputes or distribution disputes where you may have particular methods of operating that are protected by trade secrets. Just to mention that we are keeping quite busy in the current situation, and we have seen a big increase in the caseload last year and also this year. And of course, as Claire was mentioning, of course now we are in a virtual environment. The vast majority of meetings and hearings in WIPO mediation are conducted online, and we need to be quite careful also with confidentiality when we are using different platforms to deal with hearings or meetings in arbitration. Claire has already mentioned the types of agreements that can include trade secrets, trade secret issues. For instance, just to focus on a couple of these agreements, in relation to research and development agreements, we are seeing often disputes concerning breach of confidentiality obligations and, for instance, use of confidential information in connection with certain specific subsequent patent applications, for instance, by one of the partners in that R&D collaboration. We see that quite often in the context of European consortium agreements under, for instance, Horizon 2020, the European Union program. And we are also seeing, in relation to the last category of employment consultancy agreements, often situations in the IT sector when, for instance, an employee may join a competitor and there are allegations of misappropriations of trade secrets by former employees concerning the source code, again, projects, and as Sana was saying, client lists. So these are some specific issues that we are seeing. In terms of the rules, as I mentioned, we have very detailed provisions, and I will not go through these. I think that would be quite boring for the content for this webinar. Both these provisions are available both in the mediation rules and in the arbitration rules. And in arbitration, they're very, very detailed. They preserve the existence of the proceedings, disclosures made in the proceedings, and the award. And in relation to the award, what we have seen sometimes is that you have two different versions of the award. So you may have a full version with details on the trade secret, and then you may have a redacted version of the award excluding that trade secret. And of course, the more comprehensive version of the award may be easier to follow than the one where certain things have been redacted. Article 54 of the rules is the provision which is really specifically on trade secrets. And of course, trade secrets are defined in a way that Sana was describing. So they define confidential information as information in the possession of a party, not accessible to the public, of commercial, financial, or industrial significance, and treated as confidential by the party possessing it. What measures can be adopted to protect the confidentiality of trade secrets? As has been mentioned before, admissibility and privilege. And I think Patricia is next going to focus on this. What we see very regularly is redaction of confidential information, either from evidence, but even from pleadings. We also see protective orders with some regularity, and I will mention a couple of examples in a minute. What we see less often is the provision on confidentiality advisor, which, as far as I'm aware, is something unique of the WIPO rules and has not been used very much, and maybe we can discuss later why it has not been used so much. But in terms of the protective order, which is the most commonly used procedure, of course, you need to have an application by one of the parties. And then, of course, that application will have to be decided by the tribunal, and that will decide whether this information is going to be confidential and take some special measures of protection. And I will give a couple of examples in a minute. So the first example is a case involving an inventor and a sports goods manufacturer, a big multinational company. In this case, it was allegations of patent infringement made by the inventor, and they had a WIPO expedited arbitration clause. Here there were quite complex legal and technical issues, and the US manufacturer became quite concerned because the inventor, in parallel to while the arbitration was going on, the inventor seemed to be negotiating with one of the competitors of the US manufacturer. So they were very worried because the inventor was seeking to obtain information concerning manufacturing processes, and therefore they requested a protective order, which included the elements mentioned in this slide: the designation of confidential materials, restricting the disclosure to certain parties, the filing of designated materials, and in this case it was still through sealed envelopes, which sounds now very old-fashioned, but this is what happened in this case. Then what would happen once the designation had been completed, and then how these materials would be disposed of at the end of the arbitration. In a more recent case, and this case is in the film area, it relates to an animation movie which was a co-production between Europe and Latin America. Here, it was quite interesting because the parties were using an online production platform where they were kind of working together and providing different contributions to this project. And once the arbitration started, one of the parties blocked access to the other party to this platform. And therefore they could not even use the information or the materials that they had filed in this platform. And therefore they needed to have access, and this was done through a protective order, which again designated certain materials and restricted access to those materials. And in this case, they adopted some technical measures to prevent the downloading of the materials. And there was also a log, an access record of who was able to access these materials, and there were also some further confidentiality undertakings. So these are two examples of the type of protective orders that we see. And of course, I will be happy to discuss later on in a little bit more detail about the confidentiality advisor. But thank you very much for now.
We're back. Very good. Ignacio, thank you very much for that contribution. And again, there's much food for thought and questions to arise later to discuss. Moving on then to Patricia to share her thoughts from the perspective of having been appointed as confidentiality advisor. Patricia, the floor is yours.
Thank you very much. And indeed, there's been a lot of interesting things that we can be discussing in the discussion section. But as I was stated, I'm going to focus on the role of a third-party neutral to be assisting as a confidentiality advisor, sometimes called a master, sometimes called an expert, sometimes called a document production manager. So there are different titles for this role. But let me start by noting that this rule, or this role in some roles, is nothing really new. It actually has been around for well over 40 years in the United States, and it evolved particularly in the context of extensive discovery in litigation in the US. And so actually the very first appointment that I received in this role was over 35 years ago. when I was asked by a court to take on the role of determining confidentiality issues that arose in a multi-institutional, rather large, complex financial institution litigation. And so there were lots of claims about confidential information not being revealed, particularly to competing financial institutions and to potential authorities and such. And so this has been around for quite a while. And it has become increasingly observed in the international arbitration environment, just as production of documents, documentary evidence has become more and more common in the context of international arbitration. Now, in the context of international arbitration, it raises some particular issues, and not the least because it often involves cross-border relationships and transactions. And so the confidentiality issues take on a whole range of different types of challenges and issues to be addressed, and are subject to very different legal regimes. So even identifying sometimes what might be the nationality of the particular claim of confidentiality, what would be the nationality of who is in possession and responsible for controlling the confidentiality, what is the nationality of the legal rules that might apply, that all of these can become a bit of a complex matrix. So having said that, trade secrets, of course, are very different than other kinds of confidential issues, and they arrive very much in the context of technical disputes, as we've been discussing. And they're different in the sense that they are do not come from the same basis of evidentiary privileges, which are embedded in procedural codes that you would see for things like legal privilege. Perhaps in many jurisdictions, you may have patent advisor privileges, and then you have these different blocking statutes and things which have occurred in that environment. So in the context of trade secret confidentiality, when we're talking about confidentiality that has been given in order to enhance economic benefits from this protected material, they have a slightly different features in which they arise. And so going to an advisor, the question can be asked, why go to an advisor? And as we've been discussing, there are methods for trying to manage and maneuver to protect needed confidentiality in this area by having protective orders and perhaps having restricted access so that you have attorney's eyes only, tribunal eyes only. You may have a limited room with a neutral in the room. But oftentimes this, and particularly in the context of international arbitration, where the role of the arbitrators to maintain their independence, impartiality, the right to be heard, equal treatment, the arbitrators must be very careful that they ensure that they are not receiving information that may affect their adjudication of the issues, which the other party is not aware of what that information is. And the other party may not feel comfortable with the information having been given to the arbitrator, even if the arbitrator determines that it is confidential and should not be considered in the adjudication. You know, it's, as we all know, and we've seen cartoons, you know, about the judge being told to disregard or the jury, what's just been heard, you know, it's putting neon lights around it. And as counsel, it's often, do you want to make an objection and get everyone's attention on it, or hope it slides under and doesn't get much attention and is forgotten? But for important trade secret information, counsel can't take that risk. And so that the question is how to preserve and to ensure that confidentiality is protected, but is not abused. Because of course, the concerns of the party that has not been able to see the allegedly confidential information, there are great concerns about whether or not this is a claim which is overly broad or not justified, or that maybe the information which is being sought to be closeted is exactly the information which is needed to fairly adjudicate the specific issues in the case. And so that leads to the entrance of the neutral, independent confidentiality advisor or expert or whatever that terminology may be. And as we've seen in the presentation of the WIPO Rules 54, which provides that in exceptional circumstances, such a neutral can be appointed. And we see that same solution in the IBA Rules of Evidence in Rule 3, subsection 8. Again, in exceptional circumstances. I won't go into what are those exceptional circumstances. I think our next very qualified speaker may be in a better role to say when that might be justified. But let me move then into one thing about the importance of the role. And the importance of the role is that the neutral is there to provide a service for the parties and for the tribunal. The neutral is not supposed to be participating in the adjudication of the decisions that lead to the outcome of the case. And that can be a pretty fine line to walk when dealing with confidentiality determinations in cases where the trade secrets, the confidentiality, are at the heart of the dispute. The neutral should not be the fourth arbitrator. And that may be one reason why sometimes it's suggested that an appropriate third person neutral might be the secretary to the tribunal. But some may have concerns that the secretary to the tribunal is working closely and maybe unconsciously or indirectly affecting in the discussions some of the thinking of the tribunal. So it's important for the neutral to be aware of that careful role and staying neutral. And maybe we'll go more into the details after we've completed the first round of presentations here about the instructions. The instructions of the terms of reference and how they are given become very, very key, even more so than when it's a tribunal appointed expert on a regular technical issue, because then those experts may be subject to competing experts by the parties. There may be cross-examination, there may be certain reports. So as a confidentiality advisor, you're not in the same position as a regular appointed expert. Now, in the scope and the mandate and the instructions, there may be provisions for the parties to be able to express some opinions on the reporting and the assessment of the advisor. So that's something to consider. Typically, the parties have agreed, and typically the parties are going to pay. If a party doesn't agree, then it creates a more difficult situation to maneuver for everyone. I have had situations where oftentimes in commercial arbitration, the tribunal will encourage the parties to go through document requests and production without involving the tribunal until an issue arises. And then an issue has arisen as to some redactions that are being made or documents which are claimed to not be appropriate to be produced. And so I've been approached in some cases where the parties themselves have asked me to go through the documents and to determine if the redactions are overly broad or if justified, and given me very little instructions. So I actually have the pleasure, I can say, and shoulder the responsibility to actually be doing the research with some submissions by the party as to what might be the applicable legal standard for my determination. Having such a long leash sometimes can be discomforting, but in some cases that perhaps the issues are not, the case is not so highly valuable and the issues are not considered so key, then I've been given that very long leash or wide discretion. In other cases, it might be that the tribunal has consulted with the parties and they agree to the appointment. And so the tribunal has suggested me and then the parties have agreed. In other cases, an institution or organization has been the appointing, and then that leads to who's directing the work. and who I am reporting to. And how are those instructions and mandate? And sometimes the instructions have resulted from procedural orders by the tribunal in cases where there's been a lot of issues relating to large production documents. And so that then I need to be the hands and the eyes that are applying the tribunal's instructions. So the degree of control varies, but it's something that counsel should be thinking about instead of just kicking into the neutral and hoping for the best, and whether or not there's any opportunities to have opinions upon the report when it comes in. And again, the manner in which reporting, typically you might have a Redfern schedule, Stern schedules have become popular. They're in more complex cases, there may be encrypted data rooms that you have a limited access to. And so that you're working in that phase. And of course, neutral needs to sign a confidentiality agreement, which can be very detailed and would perhaps include provisions relating to the destruction of all the information within a certain period of time. So with that, I hope I've opened some questions that we can share experience and ideas, not suggesting that one should overcomplicate, but like everything in international arbitration, the beauty of international arbitration is we can find flexible, bespoke procedures which are suitable for the particular issues in the case, the parties and the tribunal's needs. And so I think at this point, I can turn over to an excellent tribunal, Sarah Reynolds, who will tell us what is the perspective from the tribunal.
Thank you, Patricia. I will try to be brief to keep us on schedule. And my co-panelists have done such a great job covering this issue. They haven't left very much for me, but I do have a few points to make. From the tribunal's perspective, which, whether it's a trade secret misappropriation dispute or a dispute where information related to a trade secret just happens to be pertinent and therefore subject to disclosure, the tribunal really does have a few tools that they can consider, and you've heard about a lot of them already. And the primary one are orders, right? We've heard about protective orders from a number of my co-panelists already. And this is a relatively sophisticated arbitration crowd, just scrolling through our participants today. And so we don't need to dwell on the point, but as many of you already know, privacy and confidentiality are certainly advantages of arbitration, but arbitration proceedings are private, right? The public can't participate, but it's important for parties to always understand and be reminded that confidentiality, in contrast, is not an essential attribute of most arbitrations. And rules related to confidentiality and arbitration vary among jurisdictions and among the various arbitral institutions. In the United States, for example, the FAA, our Federal Arbitration Act, and the Uniform Arbitration Act that's been adopted in most of the states of the United States don't actually impose confidentiality restrictions on arbitrations. Many arbitral institutions, almost all arbitral institutions, have confidentiality rules, but they tend to restrict arbitrator and staff from disclosing information and really don't address binding the parties. So given the absence of any rule-based or implicit duty of confidentiality in most jurisdictions, the UK is a developing exception. Parties often explicitly agree to maintain confidentiality in their arbitration clauses or in the terms of reference that Patricia was referring to earlier. You heard Claire talk about confidentiality within proceedings vis-a-vis the outside world. A really good protective order will protect confidential information in both instances. And so as a tribunal, if trade secrets are involved, the focus is going to be on ensuring that there are clear procedures in place to deal with that information. So the first place for the tribunal to look is going to be the parties' arbitration clause to see whether it includes terms for protection of confidential information or incorporates any relevant rules. And if there isn't sufficient procedural guidance there, then as Ignacio explained, the tribunal can issue a protective order detailing such procedures. Sometimes these orders are drafted by the tribunal and just handed down to the parties. Other times the parties negotiate a draft and present a consensus draft to the tribunal to sign. And then you also have instances where the parties can't agree or come to a consensus, and so they each submit, their preferred version to the tribunal, and then the tribunal has to either choose one or develop a hybrid. This is speaking to the, beautiful bespokeness that Patricia referred to of arbitration, that you have all this procedural flexibility to reach a place that honors the priority of the parties. And because the parties generally will have a more nuanced understanding of what information they have and what information they need as evidence in the proceedings, I generally prefer if the parties can reach consensus and draft an order. But again, where that's not possible, there are plenty of other options to reach a good protective order that will provide that protection both within the proceeding and outside of it. And then again, the terms of reference is another great place to provide further detail on how that information is going to be treated, and to sort of incorporate the rules that are in the protective order. Patricia mentioned some post hoc situations that arrive where there isn't clear procedural guidance on what to do when there's a problem, and so the parties in the tribunal are coming up with a plan after the fact. Obviously, it's better from a procedural fairness and efficiency perspective if that guidance is nailed down early on in the proceeding. And as many of the panelists have talked about, procedural flexibility and that ability to be creative is really helpful in these circumstances. For example, if one party demands access to information that another claims is a protected trade secret, the tribunal has a range of approaches that they can employ. Some that are more and less extreme, depending on the party's priorities and on the, degree of sensitivity of the information at issue. But for example, we've seen tribunals require a prima facie showing that a breach occurred, or whatever the claim is, before requiring disclosure of sensitive proprietary information. It's a bifurcated method that prevents the parties from using arbitration as a way of conducting a fishing expedition. And it also prevents a party from obtaining improper access to another party's valuable trade secrets. And it just increases assurances all around that the parties won't have to disclose trade secrets when there isn't a legitimate claim against them. So it's a more extreme measure, but a good one to keep everybody honest. And as Ignacio explained, the use of third-party confidentiality advisors can be really helpful here as well. You heard Patricia talk about the details there. And that party can review the information and make determinations. And again, it just increases everyone's assurance. I won't go through the details since I think you've heard them now a couple of times, but it just increases everybody's assurance that neither party is either using a claim of trade secrets to shield harmful information, or seeking unnecessarily, seeking irrelevant information just to gain access to a competitor's trade secrets or other proprietary information. And then, as there are other accesses for restricting access that have been talked. Attorney's eyes only is a really common one, and while it's procedurally a little bit clunky to implement, it's relatively efficient, and in my view, and sort of most normal baseline cases, is a great way to raise everybody's comfort levels with respect to protection of that sensitive information. And so, in that version, the lawyers have access to the information so that they can bring a robust case to the tribunal, but their underlying clients don't have access to the trade secret portion. So again, it's an effective method, but a little bit cumbersome in that the client can only review redacted portions of submissions and may be asked to leave hearing rooms from time to time in order to exclude them when trade secrets are going to be involved in testimony. But again, it's a good, relatively efficient method for achieving those goals. The point of abuse has come up a couple of times here, and it is unfortunately not uncommon to see parties abuse trade secret claims, similar to what we see with overreaching privilege claims. And it is important that tribunals be aware of that risk and that they ensure procedural fairness when they can. That really is a keystone of arbitration, and we all benefit when people view arbitration as a fair procedure for resolving disputes. The good news is that disclosure of trade secrets to other parties in an arbitration or to the tribunal is generally thought of as less serious in terms of a procedural fairness issue than disclosing information that's protected by privilege. There's less likely to be a prejudice argument there. And then hopefully you have, you know, a good solid terms of reference and protective order and other applicable rules incorporated into the dispute to protect external exposure of that information so that that doesn't become a wider problem. And then, you know, secondly, when the right tools are implemented, disclosure of confidential information within an arbitration is just less likely to result in inadvertent or unfortunate occasional intentional broader public disclosure than what you risk in a domestic court. And then the last point that I'll make is that, you know, one of the great benefits of arbitration is the parties' control, and one of the ways for them to exercise that control is that they have an opportunity to pick or at least provide input in most instances to who will serve as the arbitrators and who's going to constitute the panels. And in many cases, the parties can conduct research on potential panel members to see how a candidate has treated disclosures or even trade secrets in other proceedings. And parties can also select candidates with certain technical or legal qualifications so that these issues are not new to them and that they're not, you know, struggling with the basics. So for example, the parties can select candidates with experience in trade secrets, with, you know, a relevant type of IP, or even just exposure to some more general technical concepts that might be helpful. And because I want to keep us on time, I'll end there. I know we're all looking forward to the discussion component here.
Thank you, Sarah, for your introductory comments. Thank you very much. So, lots of questions arise, but let me start off perhaps with an easy one to all of you, but perhaps Senna can start off with sharing her views. So, what are your main concerns that you have if there is an arbitration when trade secrets are at stake? I could think of a couple, especially if there are tribunal members appointed who are no longer working for a big law firm, for example, that they are emailing with the parties from Gmail accounts. The immediate concern that I would have is protection there, due to the potential insufficiently secured emails that are being used. But I'm very happy to hear all of you what your main concerns are. Sana.
So if I tell you about my concerns, I might come across as a bit paranoid. But let's say I'll be the devil's advocate. It's scary for an in-house counsel because first of all, you cannot assume the arbitration is confidential. Let's assume it is confidential, and let's assume all the right measures are in place. Now, vis-a-vis the other party, at the end of the day, a trade secret is just a piece of information, right? It can be memorized, it can be photocopied, it can be scribbled down, it can be a clue, thanks to which you will understand how I function internally, thanks to which the other party will know my commercial strategy with them. It can be shared outside the arbitration room. I can be extreme, but it can be monetized as well. So the risk is there. And I really will challenge my co-panelists to help me identify very efficient ways of protecting my trade secret. Nowadays, in an economy that is based on knowledge and on mobility, it's difficult to think that your trade secret will be completely immune and will come out safe of an arbitral proceeding. Imagine if someone is there and uses mass media communication, internet, intranet to post a trade secret. That, even if he or she will take it back, that by itself will make my trade secret lose its status of trade secret, because it was potentially available to millions of people, even if only a few people see it. But probably those who should not see it, will have seen it. So the risk is there. I think one of the risks as well is that the tribunal and the other parties to the arbitration do not grasp or do not understand the relevance and the sensitivity of the information to me, and do not probably put the right measures in place. But let's assume the right measures are in place. And I was interested in the protective orders summary that Ignacio made. And this is very reassuring to know that you can have protective measures, but then what's the sanction of if someone breaches the protective measures? What will happen? I mean, I have been very often disappointed with the treatment that confidentiality breach claims have received in arbitration. Sometimes they are overlooked, sometimes they are minimized, sometimes, they do give you compensation, but then how much will you compensate me for the loss that I will incur by my trade secret, having been disseminated or known to someone else? Let's think that, once again, it's a world of mobility. You never know who my vis-a-vis party will be in the future. Probably they will be my biggest competitors, after a merger or an acquisition. Their employees can go and work for another firm. I mean, how much firewalls are you going to put in there? So it is scary. I mean, these are all worries that we keep in mind. Also, as an in-house counsel, the other party is probably my enemy during the arbitration, but outside of the arbitration is probably my most strategic business partner. And I don't want a trade secret, that comes to be known during an arbitration to impact the overall relationship that I have with them, either now or in the future. So yeah, really, really multiple risks. I have a long list, but I think I will stop here.
No, I think
just one thing. Just one thing. Yeah. And I liked what Patricia said. She said, if I see something awkward happening, do I object? Do I raise my hand, or I just act as if I had not realized anything and hoping that the others did not realize it? That's a difficult call that you have to make. And if you decide to show that or to raise your hands that you realize that there was a trade secret breach, how will you defend yourself? I mean, by defending yourself will make it even more visible.
When Pandora's box is open, you cannot close it anymore. And that's a real difficulty. So you touch a real important point there, that a protective order only brings you that far. That's an order which can be breached. And if it is breached, it's going to take potentially years of additional arbitration or litigation to first, show what your losses were, go after the other party, enforce your rights, while what you say, potentially also trying to preserve a business relationship with the same group of companies. Yeah, you don't want to get into that mess. Any of the other panelists want to share in and weigh in on their main concerns?
Oh, probably reassure me.
I would be happy to share my concerns as advocates. I think for me, it really trying to balance those two considerations. If I'm on this side of the owner of a trade secret, I think my main concerns would be, how do I win this case while preserving that secret? And if I'm not if I'm on the other side, but if I'm on the side of a party who is trying to access information because there is a belief that information is relevant, my main concern would be that a trade secret claim is effectively used as an abusive process in a way that is bad faith. it's really not uncommon for parties in arbitration to use an allegation of trade secrets to shield harmful information, and I think that's a concern as an advocate, and as Sarah said, that would be a concern as an arbitrator as well, because at the end of the day, you may have suspicions, but unless you really see the information, it can be very hard to come to a view and balance those two considerations.
The only point I'll add from the tribunal's perspective is to make sure that the protective order includes clear consequences for breach. And likely you're going to want it to be clear that a breach will be arbitrated as opposed to litigated. The worst outcome in that sort of situation is for your option to be to go to a public court to have to fight about it. That will largely, depending on what the information is likely not to be an appealing option.
So Sarah, if you're looking at the various options that would exist for you as a tribunal to safeguard trade secrets, protective orders are just one of them. Attorney-only disclosure is another one. We've got the confidentiality advisor. Can you share a little bit of how you would analyze which of those measures would be best suited? And that's a question that can go to anybody actually, but first you.
Sure, I'll start us off. From my perspective, the more sensitive the information, the more appropriate it is to include layers of protection. Being mindful of the fact that each layer adds increased cost and expands the timeline of the dispute. So you want to be careful to maintain procedural efficiency while doing enough to protect the party's confidential information. As always, the tribunal is going to be guided by input of the parties as to what the priorities are. Some parties don't mind an expensive process if it really locks down their trade secrets, where others strike more of a balance. As Ignacio discussed, the confidentiality advisor is a relatively new concept at WIPO, but Patricia explained that the concept's been around in various permutations for decades. And I do think it's a helpful tool that'll prove very, increasingly valuable over time. But I don't think it's appropriate in every trade secret dispute, particularly, where you're not dealing with highly technical information or where you're not concerned about a bad faith on one of the parties. The tribunal really just has to find the right balance between protecting confidential information and maintaining an efficient and streamlined process. Sana made the good point about reasonable efforts. None of this is bulletproof. There's always a chance that something's going to get out that shouldn't. But we all need to put forth our best efforts. And from the tribunal's perspective, that's ensuring solid procedural guidelines and rules. And then, Claire also made a good point about the tension that exists between protecting trade secrets and the legitimate need for evidence in a dispute. A party might need evidence, and you can't allow the other side to shield that by calling it a trade secret, beyond a legitimate realm. And so that's what the tribunal needs to be looking out for, and deciding sort of how many layers of protection makes sense in a particular case, always being guided by whatever the parties have agreed to themselves, and whatever they're suggesting the priorities are.
The necessity of bringing some evidence into the record is an interesting one, not only from the procedural part in the arbitration, but let's say that a tribunal does take into consideration certain evidence, but is shielding that from the other side. You may have concerns in setting aside action on the first after an award. You may also have follow-up discussions in enforcement actions. So it's a very tricky decision, I would say, for a tribunal member who should render an enforceable award to balance that out against each other. Any further thoughts from Claire, for example, or Ignacio?
Well, on this last point, Stan, I've had this experience where there was a suggestion made by the producing party that it may simply produce the evidence to the arbitrator. Well, in that case, I think the arbitrator I was acting before was right to refuse that, you know, and as an arbitrator, I would be very concerned to be privy to documents or information that has not been seen by the other side. As you said, that gives rise to due process concerns, but also potentially actually could be fatal to the enforceability of the award. So we need to be sometimes mindful that, you know, even in instances where there might be an agreement reached, you know, this is something for potentially for an arbitrator to raise and refuse to do.
Yeah. Sana, I had some additional questions relating to your in-house perspective and the measures that you would take yourself as a corporate. Starting point is that you need to take reasonable steps towards protecting your trade secret yourself, and you've explained a little bit how you can do that with confidentiality agreements for employees and secret stamps and what have you. But I think it's interesting to see what you could do and take as measures to not get that far that you end up in a dispute on trade secrets in an arbitration. As far as I know, the recipe of Coca-Cola is still a secret, but how do they go about, or you with your trade secrets in your corporate, to really ensure that you can compartmentalize information, sharing only pieces of information with certain employees, but what is your basically the best level that you yourselves are implementing?
So once again, it'll be just personal views. I think that every company should have a process that works for it and for its employees and for its industry. And there's no, you know, fit for all, I think, a process. It will depend on the kind of business you are in. So I was talking about reasonable efforts and true. However, some of the efforts have to go beyond just being reasonable. If it's a source code, if it's a formula that is being developed, then yes, it should be more than reasonable. It should be maintained strictly within the people who absolutely need to know about it. So whether it is a physical Chinese wall, or whether it is a theoretical one, we have to make sure that the information doesn't leak within the company.
And within the persons that then are on that very strictly need to know basis, I can imagine that in their management or employment agreement, there's a strict requirement and a significant fine. But and the stronger the secret is, the higher the penalty may be in an employment agreement. But you know, going back to the Coca-Cola recipe, you know, if the penalty in the employment agreement is 1 billion, you may be able to convince somebody who has bad motives to make that billion payment if push comes to shove, and that penalty has to be paid. So it's still a difficulty.
Oh, absolutely, absolutely. And there is no black and white answer here. And you know what? Many times I think that the protection doesn't only lie with legal processes and legal measures. Sometimes it has to do a lot with your ethical standards. Sometimes it has to do with how clever you are when you hire someone. Will you be able to identify the right person? The fact that some recipes are still kept secret means that you've been successful so far, hiring the right people, putting the right measures in place. So I'm not, how to say that, I'm not desperate that these, exist, but it has to be not just one measure, it has to be like a battle on different fronts. Ethical, having the right resources, having the right measures. Penalties, I know they're dissuasive, but I'm not sure this is the most efficient, how to say that, measure. I think developing the right and healthy company culture is very important, because it's becoming like safeguarding a family secret at some point. So you have to make sure you are invested personally in making sure this secret, is kept secret. So to your point, and this actually probably goes back to what I said concerning the arbitration. There's no, you cannot be 100% safe, but you have to do your best and probably beyond. And you have to make sure that all stakeholders are involved and put together all the technical, legal, and other measures in place.
Yeah, thank you. Ignacio, I also had a couple of questions for you.
I just very briefly react
Yes,
because I think there's a very good question on the Q&A from one of the participants, and which I fully agree. I think the breach of trade secrets, the damages are irreversible, and I think we need to acknowledge that however much we try, arbitration doesn't provide a full answer to this situation. And this is not a WIPO case, but I mean, recently I was discussing with a Chinese IP lawyer, and he was telling me about a trade secrets case arising out of an employment contract where one of the employees had moved to a different company, and really, I mean, they have all the protection. The company had all the protections in place. They had protocols. They had everything. But really, when that employee moved to a competitor and started to disclose source codes and client lists, they went to Interpol. So that's just is something that however hard we try, we cannot do within an arbitration. And I think we just need to acknowledge that there are some limits on what we can do.
Thank you. Now that we're with you, Ignacio, you also touched upon the provision that is in the WIPO rules on the possibility to appoint a confidentiality expert. We've also heard already that it is still somewhat new. Can you share a little bit of information to the audience as to how often it is used at WIPO? Is it being promoted, or is there something? Is that something for us as a community to promote it more?
I mean, it's not a new procedure. It's not a new rule. It's been there since 1994. It has been used. It has been requested in a very small number of cases, and when it has been requested, what we have found is that the tribunal has been very reluctant to appoint an independent confidentiality advisor. And of course, if you look at 54 paragraph D, it's the tribunal who could designate the confidentiality advisor. It's not the parties. And therefore, I think there's a concern sometimes that on the part of the arbitrators that they may be left out of some information that could be quite relevant. So this is why it has not been used. We understand that it has been used in some ancitral ad hoc proceedings, and they used the WIPO provision just to appoint a confidentiality advisor. But in WIPO proceedings, it has not been used, and instead, protective orders have been put into place. Right. Even in this area of FRAND related disputes, where there's some very sensitive comparable licenses, they have managed to go around that by redacting and putting into place protective orders instead of appointing the confidentiality advisor.
Well, I guess from a procedural and equal treatment of the parties principle, that is the best way to move forward, if you can allow that. But Patricia, this may be of interest to share your views on, because if we hear Ignacio speaking about the lack of the appointments of confidentiality advisors, and you have been appointed as confidentiality advisors on a number of occasions, have you seen the same sort of level of conservatism on the part of tribunals, or can you share some of your views there?
Well, you don't know what you don't know. So I don't know about those tribunals that may have considered it or parties that may have requested it. So I really can't speak to what the approach is. It might be partly that it's relatively new, and then also perhaps some tribunals are concerned about letting this issue become the tempest in the teapot. They may think that one of the parties is now creating a big issue around this that doesn't need to be, and that by appointing a neutral, it's going to cause delay. In one case where I was appointed, it was 2 weeks to the hearing in a large investment case, and then in the dispute between the parties relating to redactions and unproduced evidence was going to potentially cause a long delay. So I was asked if I could go through an extremely extensive number of documents and to have completed the assignment within 1 week. And that was a challenge, because within that week I was flying to China, and I didn't want to work in any kind of insecure environment with this encrypted thing. Anyway, but I managed to complete it with 1 hour to go and sent it off, having worked all night through. But I can understand that the tribunal would be concerned that if one of the parties is perhaps asking for this procedure as a way to obstruct or delay or to whatever. That was not the case, I think, in this case at all. But so that, but one thing, let me mention that one of the issues that comes up, you've been talking about it, brings to mind this idea of waiver. And oftentimes in different types of confidentiality situations, the thing that becomes the decisive factor is whether or not the parties have actually created and maintained the confidentiality, or if there is some waiver, and depending upon what legal standards you're applying, you may have, I think it was being intimated to by one of the previous speakers, by Sarah, I think, you may have a very broad subject matter waiver by having put into play some of the evidence. So you can't take a little bit of the evidence and put it in and then not provide other contextual evidence. So that can be an issue, as well as particularly when you're dealing with trade secrets, you might be in some legal environments where there's an in-issue waiver, that if you have made claims or defenses that put that exactly right in issue, that you can't put your claim on that and then say, but I can't provide the evidence. Anyway, without unpacking a lot of technical legal things, I think you have to look at it in a bigger picture. And that's going to be the challenge for the tribunal, the parties, and for any third party neutral. And that also can be something to consider when, again, giving any instructions. So that was kind of a very broad non-answer to your question.
You were talking about the leash earlier on, that was very loose. And we've just heard Ignacio say that there might be some conservatism on the part of the tribunals. So you see basically both ends of the spectrum there. But I could imagine that certain tribunals, if they are a bit conservative, but they are there to appoint a confidentiality advisor, that they still want to be very much part of the process and put terms of reference in place that are very narrow for you and allow less space for you to maneuver freely in. Whereas on the other side of the spectrum, they can leave it all open to you and do as you please. Can you share some of your views as to how you would go about in those both two extreme situations.
Well, I don't really know until I'm in the situation, and each one needs to be addressed according to its context and whatever instructions. Not many or many, but let me say that let's say, for example, there's an issue about whether or not this information is protected. Now I'm going outside of trade secrets, but let's say whether or not it's protected because of communications with a patent advisor or with the in-house counsel. And as we all know, that can be very varying, particularly when we get in the details in different jurisdictions. And so if a tribunal has already made procedural orders about what is going to be the law applicable to particular evidence or to particular identities of different issues, and then I just simply become the eyes and the hands of the tribunal in applying the instructions. And if need be, you could perhaps go back and say, I need some further clarifications. Then you have that comfort that I'm not the one who's making the decision that could be the felling blow. I'm just applying what are the rules of play that the tribunal has put in, even if that has a decision-making function. So it's very different if I'm going to become the one who is going to determine whether or not these particular groups of documents have been too widely shared within the corporation, too many not need-to-knows, if they haven't been carefully protected confidentially, if this it is not subject to a protection according to some other rule. So that's something that whether or not that's a comfortable situation or not depends on the context, but it's things that should be considered. And it also can take more time if the neutral is having to engage in that. And then you could say, well, typically, if you were engaging in issues about those kinds of things, parties would be making submissions. And as a neutral, you're not usually getting submissions from the parties. You're getting instructions that hopefully the parties have given to the appointing tribunal or organization. So I can see that, and that also, in some of these cases, you need to have a significant sector technical expertise. You know, in some cases, I might not at all be an appropriate person because I don't have that understanding of that particular sector. So that would, you know, so that needs to be considered too.
Yeah, yeah.
But on the other hand, if I may add to that, if the arbitrators do not have that expertise in that type of technology, for example, the need to appoint a confidentiality advisor may be even greater, right? So you know that you'd have the benefit of a neutral looking at those issues, but also you'd have that neutral's expertise. You know, in some cases, just accessing the information, the data requires expertise. You know, I think there's something to be said about you know, the value of arbitration in terms of being able to appoint arbitrators with expertise, but also, you know, incorporating the ability to incorporate expertise in the process in other ways, you know, whether this is for the determination of the issues, so the adjudication of the case, or actually dealing with evidence.
Yeah, thank you for that contribution. I think it's a little, we're at 6:15. We have about 15 minutes left. It may be appropriate now to turn to the questions that were posed by the audience. Let me take a look at those. Right, first question from Pierre de Ravel Desclapon. Sorry for that, my French is not that good. Will the slides be distributed? I think we'll have to discuss that briefly with Ignacio. If he is happy to, I'm sure that the SVAMC
be happy to share them.
Yeah, I'm sure that then in turn the SVAMC will be happy to either send it through to the distribution list or post it on the website. Right. Ignacio, while we are with you, a couple of questions that I see that are mostly directed in your way. In the same way that the validity of registered IP rights can cause arbitrability concerns in certain jurisdictions, is it not arguable that issues related to the validity of trade secrets cannot be arbitrated, since the award can potentially affect members of the public who were not given the opportunity to participate in the proceedings?
Okay, so this is the standard question when we talk about IP arbitration. IP disputes are arbitrable in most jurisdictions, in the vast majority of jurisdictions, and the effect, of course, is going to be normally restricted to the parties. So, of course, as most arbitrations, the award does not have an effect erga omnes. It only has effect as between the parties. And the same applies to trade secrets, patents, trademarks. I see that there's a second part to the question. No, there have not been any cases where arbitrability of trade secrets was an issue. And in relation to the other rights, arbitrability has sometimes been raised as a defense to allegations of infringement, for instance, of patent infringement. But normally it has been handled by the tribunal, who has decided that the issues were arbitrable. But as I said, the result was limited to the parties.
Yeah, it is a very interesting issue, arbitrability of these kind of disputes. There are, as you said, Ignacio, various jurisdictions that consider this issue differently. And there may also be a distinction between the exact type of right that can be arbitrated or not. And probably the patent itself may cause the most difficulties, but other more softer rights may be more easily arbitratable in jurisdictions where the hardcore patent infringement could not be arbitrated. But this is a point that really needs a detailed analysis of which kind of case you are involved in, what the rights are that are in disputes, where they are registered, where the parties are registered, and where you want to enforce rights eventually. And I think, you know, it's a combination of all those factors that make these cases very interesting, but also quite complex if you're involved with this from the party perspective. No. Right. Moving on then to Philippe de Robert. To which extent does it help to evidence that an actual trade secret governance program was in place well upfront and obviously not an on-purpose stand? Is there anybody who would like to take this question? Claire, I see you making some indications.
Absolutely. I mean, I think ultimately it may be that a leak occurred. That doesn't really mean that the appropriate steps were not taken, right? So it will help. It will help to show that there was a process in place, as Sana recommended, that people involved within companies have a think about that. Having a process in place will certainly help, and that could be it could be in relation to preservation of certificates in as part of consultant agreements, employment agreements. It could relate to technical measures. So, for example, encryption, Chinese walls being in place within companies. Terms with counsel, with external counsel, terms with providers. So there's many different ways in which those measures can be placed, adopted, and effectively, if there is some kind of policy agreed and enforced, that will certainly help. Yes.
Yeah. Coming back to the issue of arbitrability for 1 second, because I saw Mr. Edgar Mata putting a question down in this respect in the chat function. What happens or what could happen if the validity of an IP right is challenged during an arbitration? Of course, it's for the tribunal then to make a decision as to how to go about in terms of a potential suspension of an arbitration. It's of course up to a party to go and potentially request a suspension or not, while these kind of issues may be dealt with. But it all needs to be balanced out with the efficiency of proceeding forward and moving forward towards an arbitral award. Sarah, could you share a couple of your views there?
Yeah, I think in that instance, jurisdiction is just going to matter so much since there is variation among jurisdictions on this point. And so, you know, the first issue that the tribunal is going to have to deal with is whether or not they actually have jurisdiction to decide on an infringement issue. And so that analysis will have to be done upfront before they can proceed. Obviously, an unenforceable arbitration award, nobody wins. Everybody's pretty unhappy. And that affects the validity of arbitration sort of writ large. So the tribunal is always going to be working to protect the award and is going to want to avoid deciding any issue that they don't actually have jurisdiction to decide. So that'll be a really careful analysis. It's going to involve, you know, looking at, you know, which domestic laws apply, if there's any mandatory law apply, what have the parties actually agreed to in their arbitration clause, with whether or not, you know, issues like that were excluded from it or, you know, explicitly included. And so that, you know, and that'll be a careful analysis that will probably involve consultation with the arbitral tribunal, because everybody's going to want to get that one right before they proceed.
Yeah. Sana, perhaps anything to add? Have you seen these kind of issues delay, let's say, the resolution of dispute? You just want to go ahead with doing business, of course, rather than keeping the dispute alive, so to say.
So there's actually a clash between two dynamics here. The dispute is about past facts, right, that we're trying to solve. And then as an in-house counsel, I must be always forward-looking. I must be looking at business and the life of my company from a constructive perspective. So I should not let an arbitration be in the way of the creative activities that my company should have. And I shouldn't allow any unnecessary measures, requests, buy time kind of claims get in the way of an arbitration end of my company's life. I think I'll go back to the same comment that I made earlier, but actually I would like to expand on that. I think that the key here is common sense and ethical standards, right? You as lawyers, as arbitration lawyers, as arbitrators, you know, have to realize that there is a life beyond the arbitration. There is a life in parallel with the arbitration. And it's not about winning at any cost. It's about preserving the interests of your clients, you know, at the end of the day. So I've been in instances where the other party, you know, would be recklessly submitting discovery claims or requests while they know that they are not really targeting the right, how to say that, argument or topic, just because they need to buy time. This is not ethical. This is not nice. And then second, if we want us to live in a more ethical world, I think we all have to make an effort. To the same way that I would like the other party to treat my trade secrets in an ethical way, I will make sure that my internal clients do the same with any trade secret that they may come to know. For example, imagine there is an arbitration and one of my clients get to know of a trade secret. I have to make sure that he or she understands that this is strictly for the purpose of the arbitration. And I have to make sure to protect him or her so that they don't get pressure from colleagues wanting to know of the trade secret of the other party, for example. So I think it's a collective effort. It's a mitigation strategy that we have to put in place, all of us. That was probably a longer answer that you expected.
No, that's quite fine. But on the subject of time management, we do have to be cautious indeed, and I think we should have covered the Q&A session then by now. Otherwise, we'll be running over time. I'll gladly hand over the floor to Sarah to provide some closing remarks, and I thank you very much, audience, for having been with us.
Thanks, Dan. Claire made the important point that because of a combination of factors, trade secret disputes are on the rise. We have an increasingly mobile workforce. People with access to sensitive proprietary information change jobs with increasing frequency. The transition to electronic data transfer makes it easier to take and move that data. And certain changes in patent law often make trade secret designations a more attractive method for companies to protect those assets. We also see a broader range of companies developing trade secrets. It's not just traditional technology companies anymore. Lots of companies have manufacturing and other back-end processes that involve trade secret information. Sana gave us the great example of the ice cream company. That's a good illustration of the point. And considering all of this, we see trade secrets playing an increasing role in arbitration, both as a central issue, trade secret misappropriation claims, and also as an ancillary sort of sideshow in disclosure processes. And it's well known that arbitration is a dispute forum that provides parties with more control and more opportunities to ensure privacy and confidentiality. That's not news to anybody here. And you heard Ignacio explain that arbitral institutions, and WIPO in particular with Article 54 and other measures, are really well equipped to handle those disputes. And in many cases, better equipped than a lot of domestic courts, especially, as Patricia explained, where cross-border issues are at play. So these positive arbitration attributes are really magnified where trade secrets and other sensitive proprietary information are involved either as a central issue or as ancillary evidence. So where trade secrets are likely to come into play, we really encourage parties to seriously consider arbitration as a dispute resolution mechanism and to start thinking about how they're going to protect their sensitive information early on, for example, even as early as when you're drafting an arbitration clause. And so with that, I would like to thank all my co-panelists for their insightful contributions. Thanks, Dan, for his wonderful job moderating, and of course to Les and Silicon Valley Arbitration and Mediation Center and the organizers of Parish Arbitration Week for supporting our program today. And thanks, of course, to all of you for listening.